Welcome once again to Lehto's Law. Here's Steve Lehto.
Someone sent me a hard copy of a case out of a federal court, the Court of Appeals, the Eighth Circuit. And this is a very, very interesting case. And it talks about something that comes up quite a bit on YouTube videos. And that is somebody is someplace with a camera and they encounter police. And some police don't react well when they encounter someone with a camera, especially someone with a camera who doesn't necessarily just respond to what the police say or ask of them. And so then the question becomes, what happens when these things escalate? And so in this case, the case is Daniel Thomas Robbins versus the city of Des Moines. So this happened in Iowa, and this is an appeal from the United States District Court for the Southern District of Iowa. And this whole thing went down legally. The case that I'm reading to you was filed January 5th of this year. So this is really, really new as far as this goes. And what we're talking about is the court ruling. So in other words, the facts that led to this court ruling happened a while back, which we'll talk about in a second. But the ruling is very, very new. But there's a really, really good reason to be reading this case right now. And that is that the court lays out exactly what the standards are and what the laws are in situations like this. So Daniel Robbins was recording illegally parked vehicles from a public sidewalk near the Des Moines police station. So he's standing there on a sidewalk in public, and he's filming parked cars. And police officers approached him and asked him what he was doing. What are you doing? Now, they say that Robbins was uncooperative, and presumably it's because he wouldn't explicitly tell them what he was doing. But if you stood there and watched him, he's standing on the sidewalk filming cars. Now, some people are going to say, Steve, what's illegal about that? I didn't say it was illegal. But apparently, it perturbed the police. So the officers temporarily seized him and his camera and cell phone, for which he then sued the city of Des Moines and 3 of its officers in their individual and official capacities, alleging violations of his First, Fourth, and 14th Amendment rights. The district court granted summary judgment in favor of the defendants on all claims. So he filed the lawsuit, and the federal court looked at it and said, no, and dismissed the entire thing. Every count, every defendant dismissed the entire thing. And that's what happens a lot of times. And a lot of times, the lower courts will kind of look at these things, dismiss the case. But interestingly, the Court of Appeals goes through this count by count and finds some things that should not have been dismissed and sends it back down for another look by the district court. So, a little more detailed facts here. Mid-morning, May 10th, 2018, Detective Brad Youngblood left the police station to get into his car. While walking towards his car, he observed Robbins recording vehicles as well as officers and civilian employees entering and leaving the police station. So they add in here that they think he may have been filming people walking around in public. Because Youngblood was aware that vehicles had recently been stolen from and vandalized in that area, and because he was aware of a previous incident in which 2 officers had been murdered by a person with a history of filming the police, Detective Youngblood approached Robbins to make inquiry. At about the same time, defendants Lieutenant Joseph Leo and a sergeant named Curtis, along with several other people, approached Robbins as well. At that point, Robbins was on the sidewalk, surrounded by law enforcement officers. So you got the picture, right? Okay. Robbins would not identify himself, and when they asked him what he was doing, he said, I'm taking pictures because it's perfectly legal for me to do so. I'm taking pictures because it's perfectly legal for me to do so. Lieutenant Leo initiated physical contact by lifting the back of Robbins' shirt, grabbed his forearm, and placed it above his head and patted him down. Robbins repeatedly asked what about his conduct was illegal, and the officers responded that while he was not doing anything illegal, they found him suspicious. Eventually, the officers ordered him to leave. Again, he's standing on a public sidewalk, but near the police station, and they've asked him to leave. The officers then told Robbins he was loitering, and if he did not identify himself, he would be arrested. Detective Youngblood suggested that the officers just make a suspicious activity case and confiscate the camera until we have a reason for what we're doing. So when somebody says, so we should just do something, until we have a reason for what we're doing, you're doing it backwards. You should do things for reasons. You don't do things to make up reasons or to come up with reasons later. Now, I'm not talking about police. I'm just talking about everybody. So if you're going to do something that's significant, shouldn't you have a reason for doing it? Or do you really say, I'm going to do it and come up with a reason later for what I'm doing? At this point, Robbins asked, do I have an arrest? In essence, am I being arrested? Detective Youngblood said, yes. Yes. Robbins asked, am I detained at this point? To which Youngblood said, yes, you are now at this point. Of course, they usually ask that in the other order. Am I being detained? Am I under arrest? But he asked those and was told yes to both of these. You are under arrest. You are being detained. While officers put Robbins' hands on the bed of a pickup and patted him down, they again asked for identification, which he said he did not have. When asked his name, he responded with John Doe, but then he did actually give them his actual name. He said, I'm going to do this under protest, but my name is Daniel Robbins. So he did say, here's my name, and he gave them his name, and he was truthful about that. The officers seized his cell phone and his camera. Detective Youngblood photographed Robbins for his file and then told him he was free to go. But remember, they've got his cell phone and his camera. The cell phone and camera were retained by law enforcement until May 22nd, 2018. So the initial contact was May 10th. So they had his cell phone and his camera for about 12 days. The entire incident, from when they first made contact to when they left, okay, that was also 12 minutes long. That was 12 minutes long. But here's the thing. The cell phone and camera were kept by the police for 12 days. And then eventually Detective Youngblood authorized the return of the property after Robbins' attorney demanded the return of the property. So an attorney calls the police and goes, look, I represent this guy. You arrested him 12 days ago, but then you let him go. But you still have his camera and his cell phone. So they said, okay, fine, they returned it. So Robbins filed suit in September of 2018, asserting 3 constitutional torts, 3 wrongs. Count 1, he says he was unlawfully detained, seized, and searched, and his property was unlawfully seized in retaliation for engaging in protected First Amendment activity. That is, he was simply observing and recording public police activities. Count 2, he says he was falsely detained, arrested, and his property was unlawfully seized in violation of the Fourth Amendment. And count 3, he maintains the city failed to train the officers on the First Amendment right to observe and record public police activities, causing him to suffer an unlawful retaliatory detention, seizure, and search. The district court, as noted, dismissed all of those counts. So we get to the discussion by the court, and I'm going to kind of try to summarize this because it's lengthy. Courts do that. But discussing counts 1 and 2 first, and this is against all defendants. As noted previously, government officials generally are entitled to qualified immunity unless their conduct violates a clearly established constitutional statutory right of which a reasonable person would have known. Now, we recently talked about the case where Riojas pulled that out of my back of my mind. And so that law might be changing, but generally speaking, it's still going to be a while before that works its way through the entire system. The question is, has Robbins shown a deprivation of a clearly established right? Robbins asserts the defendant officers reasonably should have known that the First Amendment protects his recording activity, his verbal challenge of the police, and his refusal to leave a public space. But they point out that the officers thought they had a reason for this. They said that there had been reports of people breaking into cars, there had been reports of other things, criminal activity in the area, and another incident that escalated when somebody had been filming and asked to stop and turned into a stalking incident. And so they said that the behavior here went beyond any constitutionally protected recording activity when it was combined with the officers' knowledge about vehicles being stolen and vandalized in the area and the previous filming causing trouble, blah, blah, blah. So the court's not going to buy that one. So count 2 is the Fourth Amendment. The district court concluded that summary judgment was appropriate because the officers had probable cause for the stop under the Fourth Amendment and properly seized the camera and the phone under reasonable suspicion of criminal activity. This court disagrees. This court disagrees. When the Court of Appeals disagrees, they win. So Robbins argues the defendant officers violated his right to be free from a Terry stop unsupported by reasonable suspicion, an arrest absent probable cause, and seizure of his property without a warrant. So they will go through these things one at a time. The defendant officers argue that Robbins was subjected to an investigatory stop. An investigatory stop is a Fourth Amendment activity and must be based on a reasonable suspicion that criminal activity may be afoot. And that's the word the court actually used, in afoot. We assess reasonable suspicion using the totality of the circumstances approach, which requires at least some minimal level of objective justification. The inquiry deals with probabilities and not hard certainties, and need not rule out innocent conduct. An officer will not be deprived of qualified immunity if he had arguable, reasonable suspicion, which exists when a reasonable officer in the same position could have believed that reasonable suspicion existed. The defendant officers are entitled to qualified immunity for the Terry stop because they had at least arguable, reasonable suspicion. So simply stopping the guy and asking what he's doing, the court's saying that's okay because there have been problems in the past, and the guy's right there, and there's cars right there, and things have happened before. Based on it, they go, look, simply stopping the guy and asking him, what are you doing? That's not going to be something for which the police can be sued at this point in this case. However, the arrest is an interesting point. We next consider whether the stop progressed to an arrest. The defendant officers assert that Robbins was never arrested. But the court says they do this without meaningful analysis. The record reflects that the officers told Robbins he was arrested. If they tell you you're arrested, you're arrested. Can you imagine if a police officer said you're under arrest and you ran away? And after they haul you back or whatever they're going to do to you, you go, I didn't think I was arrested. The cop will go, what are you talking? I told you you're under arrest. Obviously, if you're told you're under arrest, you have to behave like you're under arrest. So you are under arrest and they tell you you're under arrest. This is such a bootstrap, simple argument that the idea that the attorneys on the defense side actually argued and said the man was not under arrest, even though the officer said you are under arrest. It's crazy. The record reflects that the officers told Robbins he was arrested, and then they detained him and they frisked him and they seized his property. The question then is whether the arrest was supported by probable cause. There's no question he was arrested, so let's look at whether or not he should have been arrested. Was there a warrant? No. So this becomes a warrantless arrest. A warrantless arrest that lacks probable cause violates the Fourth Amendment. Probable cause for a warrantless arrest exists when the totality of the circumstances at the time of the arrest are sufficient to lead a reasonable person to believe that the defendant has committed or is committing an offense. So there could be qualified immunity if there's an arguable probable cause which exists when an officer mistakenly arrests a suspect, believing it is based on probable cause, if the mistake is objectively reasonable. At most, the officers at the scene here asserted two possible theories for probable cause. First, loitering. Well, the problem is, of course, that viewing the facts in a light most favorable to Robbins, a reasonable officer would not have believed he had probable cause to arrest Robbins for loitering because there is no evidence that Robbins was blocking the sidewalk or disrupting the activity of the police station, both of which are required by the Des Moines Municipal Code. So he wasn't breaking that law. You can't arrest him for it. The officers also asserted that Robbins reported a false name, John Doe, in violation of Iowa's false reporting statute. Now, the question is whether or not that's a false report under the statute. But the problem is that he gave his name as John Doe after the arrest. So again, the police here came into court and said we arrested the man for giving us a false name, even though he gave him the false name after he was arrested. Now, you might go, Steve, that's crazy. It's even crazier as the district court bought it. So, meanwhile, let's get to the property. The Fourth Amendment specifically protects the rights of individuals to be free from unreasonable seizures of their papers and effects. A seizure occurs when there is some meaningful interference with individuals' possessory interests in the property. Here, there's no question that the property was, in fact, seized. The warrantless seizure of property is per se unreasonable unless it falls within a well-defined exception to the warrant requirement. They claim they've got such an exception in this case, but clearly they don't. But they pointed to some cases where other police departments had seized things like cell phones and so on. But they cite a case, for instance, out of the 11th Circuit, where somebody seized a cell phone for 2 days. But the problem here is, of course, the officers did not tell Robbins with any precision when or how he would get his property back. Rather, Detective Youngblood told Robbins he was investigating a homicide and would apply for a search warrant at some point. Youngblood disposed of his suspicions and the need for a search warrant after discovering Robbins had a YouTube page dedicated to illegally parked vehicles. Even so, Youngblood continued to detain Robbins' property until his counsel demanded their return. So, under the facts of this case, the government interest, which was presumably to dispel whatever suspicion the officers had, does not outweigh the intrusion to Robbins. The seizure was unreasonable in the absence of arguable probable cause. So, there's another claim about the training of the officers, and the courts point out that it's extremely difficult to prove that officers weren't trained properly because they simply make mistakes. So that one gets tossed and that one stays tossed. But the important thing here is that in conclusion, the Court of Appeals affirms in part and reverses in part and remands for further proceedings consistent with the opinion, and they affirm the district court's grant of summary on counts 1 and 3, but on count 2, defendants were entitled to summary judgment on Robbins' claim that he was subjected to an improper Terry stop. However, the false arrest claim and the unlawful seizure of property claim are both good. They're going to survive. So what happens here is this case will get sent back down to the trial court with a copy of this order, and the court now will have to look at it and say, okay, you originally filed a 3-count complaint. 2 of your counts got dismissed. So we're now going to have a trial potentially on 1 count. And the 1 count includes the false arrest and the seizure of the property. And they can proceed on that. Now, they might settle it, okay? Or theoretically, they could appeal this also, but they'd be appealing this one to the Supreme Court. Probably wouldn't get taken up there, I don't think. But really, what you're looking at is the false arrest and the seizure of his property. And the interesting thing is that the guy has a website, apparently, where he goes out and he films illegally parked cars. I've taken photographs of illegally parked cars. I pull into a parking lot, there's somebody, across 2 lines and across the split, so they're actually blocking 4 spots. See stuff like that all the time. But apparently the guy's got a YouTube channel devoted to this, and more power to him. That works for him. But no question that the police encountered him. They questioned what he was doing. They weren't quite sure what to make of it, and they got upset because he was, in their minds, belligerent. Now, whether he was belligerent or not, I wasn't there. But the point is that they asked him some questions, and he said, I'm on public property. I'm filming cars. And the police didn't like that answer. And so they could have thought about it some more and said, he's not breaking any laws. Might not like the fact that guy's walking around filming out here, but this is public property. He's on the sidewalk. He's not blocking anybody. He's not breaking any laws that we know of. So even though we might not like it, got to let him do that. Instead, they arrest him. Now, it's true they didn't take him into the police station and fingerprint him and throw him in a jail cell. They arrested him and then apparently decided to just let him go. But the point is they did, in fact, arrest him. They told him he was under arrest. And they took his cell phone and his camera. And they kept those things for 12 days. Now, I don't know about you, but if I didn't have my cell phone for 12 days, I'd be in a world of hurt, okay? And now, if you actually said, Steve, I'm going to take your cell phone from you, you won't have it for 12 days. I would actually go out and get another cell phone. I'd have to. I can't function without one. So I don't know if this guy's in a position to do that or not, but a lot of people aren't. So if they take your cell phone for 12 days, that is a problem. Now, is this a multi-million-dollar case that's going to, break financially the city of Des Moines? I doubt it. But what the court is saying is this man has the right to take this to court, put it in front of a jury, and tell them what happened, and have the jury decide if he should be compensated for this. And the Court of Appeals, 8th Circuit, says absolutely. He's entitled to that. He gets that. So right now, the case is still alive, and it's alive on 2 very, very easily provable things with respect to liability: the false arrest and the seizure of his property without a warrant. Only question is, what are his damages? And I've discussed this before. When you file a lawsuit to win, you need 2 things. And imagine it's a mathematical equation where you multiply things together. So if you have liability but no damages, you get 0. If you got no liability but damages, you get 0. But you got some of each, then you're entitled to go to the jury and say, hey, what do I get? And we'll see what the jury does to compensate him for what happened in his case. So the case is Daniel Thomas Robbins versus the city of Des Moines and a bunch of other people. In case you're curious, someone will ask, the man's name is, in fact, Youngblut. 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 It could be Youngblut, for which I apologize if that is the case, but I was not mispronouncing it by not saying Youngblood. So there you go. Questions or comments, do put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. You keep using that word. I do not think that word means what you think it means.